The U.S. Supreme Court has just issued a major ruling.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruin decision.
This is a case that's been bounced around back and forth throughout the court system.
Police unions versus your rights. Imagine getting pulled over in your own state while legally carrying a firearm, and suddenly the officer demands your gun, checks your ID, and questions your right to carry, all without cause. Now imagine being sued for standing up for your rights, while the officer who violated them faces zero consequences. This is not a hypothetical. Two of America's biggest police unions just declared war on your Second Amendment rights, and they are pressuring Congress to stop HR38, the one bill that could protect every gun owner who travels across state lines. If you believe the Constitution matters, if you believe the government should fear the people and not the other way around, stay with me. This fight affects every legal carrier in America. Chapter 1. HR38. Under fire. What if the very people sworn to uphold the law are quietly working to destroy your gun rights? That's exactly what's happening as major police unions rally against HR38, the Concealed Carry Reciprocity Act. This law was designed to protect lawful gun owners across state lines, but now those protections are being threatened from within law enforcement itself. HR38 would allow nationwide recognition of concealed carry permits. Police unions fear it limits their power to detain lawful carriers. They are lobbying Congress to reject the bill entirely. Their main concern? Losing qualified immunity protections. This means they could be sued for violating gun owners' rights. The betrayal is deep. The very people trusted to protect constitutional rights are now working to keep them in check, not for your safety, but for their own legal insulation. Just like in Cornelia versus Strom, the courts are already calling out overreaction, and HR38 could take it nationwide. Chapter 2. The letter that sparked it all. Behind closed doors, a powerful letter made its way to Capitol Hill. Co-signed by the Fraternal Order of Police and the International Association of Chiefs of Police, this message wasn't about safety. It was a warning. Stop HR38 or risk lawsuits. This chapter reveals the pressure campaign to kill your rights. The letter tells Congress to reject HR38 due to its dangerous implications. It falsely implies that law-abiding carriers pose risks to officers. In reality, unions fear lawsuits for wrongful detentions or arrests. The unions never mention constitutional rights, only enforcement concerns. The messaging is coordinated and politically strategic. This isn't about gun safety, it's about protecting against bad enforcement practices. The letter signals that agencies want to operate without accountability, even if that means detaining or disarming lawful gun owners. Just like in Bovee versus City of Lebanon, rights are ignored when fear takes over. Chapter 3. Lawful carry is not suspicious. It's time to set the record straight. Simply carrying a firearm openly or concealed does not make you suspicious, and it absolutely should not give police the authority to detain you. HR38 addresses this directly, forcing agencies to follow the Constitution instead of personal bias. HR38 prevents stops solely based on the presence of a firearm. Courts have repeatedly ruled that carry is not reasonable suspicion. This law would educate departments that still rely on outdated policies. It also protects against officers disarming lawful carriers. It reinforces Fourth Amendment protections during carry-related encounters. In United States versus Black, the court made it clear, carrying alone is not grounds for a stop or search. HR38 would make that principle federal law. It tells police, know the law, respect it, or face consequences. Chapter 4. Qualified Immunity Panic. This chapter gets to the heart of why HR38 is under attack. It threatens the shield of qualified immunity. For decades, this doctrine has allowed government officials to violate rights without fear of personal consequence. HR38 includes a section that starts to change that. Police unions worry they'll be sued for civil rights violations. HR38 allows gun owners to file claims for unlawful detentions. Officers who ignore valid permits could face personal liability. The bill emphasizes accountability, not punishment. Unions see this as a threat to the status quo. In Jessup versus City of Fresno, officers allegedly stole over $225,000 and were shielded by immunity. HR38 would start limiting those protections when firearm rights are involved. The fear is not about safety, it's about finally being held accountable. Chapter 5. The Reality of Armed Encounters. Let's cut through the fear. Police unions argue that HR38 will make traffic stops more dangerous, but actual data tells a different story. Concealed carry permit holders are among the most law-abiding citizens in the nation. This chapter debunks fear-mongering with cold facts. Concealed carriers have lower crime rates than even police officers. Studies show permit holders rarely commit gun crimes. HR 38 applies only to lawful carriers, not criminals. Fear-based enforcement leads to wrongful detentions. Courts have ruled that lawful carry is not a threat. The Crime Prevention Research Center found that concealed carriers commit firearm violations 6 times less often than police officers. HR 38 won't increase danger. It will simply protect citizens from officers who act on fear, not fact. And that scares unions more than anything else. Chapter 6. State laws are weaponized. While HR 38 would standardize concealed carry rights, many states currently use their own laws to punish out-of-state carriers. These states turn innocent mistakes into serious charges and, in some cases, even jail time. The danger? You can become a felon for crossing a border with the wrong permit. New Jersey and New York frequently arrest out-of-state carriers. Some states refuse to honor permits even when verified. Travelers face charges like unlawful possession or weapons transport. Firearms are often seized even if carry was legal in the home state. HR 38 would override these local traps with federal reciprocity. A real case? In 2013, Shaneen Allen, a Pennsylvania mother, was arrested in New Jersey for having a legal firearm and permit. She was facing 10 years in prison, even though she did nothing wrong in her own state. HR 38 would have prevented that nightmare from ever happening. Chapter 7. Federalism versus Rights. Opponents argue HR 38 violates federalism, the principle that states control their own laws. But the Constitution guarantees the right to bear arms, and that protection doesn't vanish when you drive across a line on the map. HR 38 reinforces rights that already exist. The 14th Amendment allows federal protection of constitutional rights. SCOTUS rulings have upheld nationwide carry principles. States cannot use federalism to deny civil rights. HR 38 does not create a new right. It defends an existing one. It stops the selective enforcement of the Second Amendment. This isn't federal overreach, it's a federal correction. Just like in Miranda v. Arizona, the Supreme Court stepped in to force all states to respect rights during arrest. HR 38 does the same for gun owners during enforcement. States can't cherry-pick constitutional protections. Chapter 8. Training doesn't justify rejection. Some states claim HR 38 would endanger the public by allowing undertrained people to carry. But this argument collapses when you look at the data. Most legal gun owners receive equal or better training than even some police departments. Most CCW permits already require firearm safety and range qualifications. Studies show CCW holders are among the most law-abiding citizens. Many states with strict training laws still experience negligent discharges from officers. HR 38 does not allow criminals to carry. It applies only to legal, vetted gun owners. The bill does not override existing training requirements within a permit holder's home state. The truth is simple. Criminals don't care about training, but lawful citizens do, and HR 38 would protect the ones who follow the law, not punish them because another state disagrees with their paperwork. Chapter 9. How the Fourth Amendment is quietly under attack. At first glance, HR 38 seems focused only on firearms, but under the surface, it intersects with one of the most critical rights you have, your Fourth Amendment protection against unreasonable search and seizure. What most people don't realize is that in anti-gun states, just carrying a firearm legally can trigger police stops, questioning, searches, or even arrests, all without probable cause. The Fourth Amendment protects you from being stopped or searched without reasonable suspicion of a crime. However, in states like New York, New Jersey, and California, lawful gun carriers from other states are routinely detained. Courts like Delgado v. U.S. and Terry v. Ohio have reaffirmed that officers need actual suspicion, not just the sight of a holstered weapon. HR 38 helps ensure that being a lawful carrier isn't treated like probable cause. In Coniglia v. Strom, 2021, the Supreme Court ruled 9-0 that even entering a home to seize a gun without a warrant violates the Constitution. Imagine being legally permitted to carry in your home state, but the moment you drive across a border, your rights vanish. This creates not only a legal contradiction, but it also creates constitutional chaos. The Fourth Amendment is not suspended because of your ZIP code, and HR 38 affirms that. Chapter 10. This is only the beginning. While HR 38 hasn't been passed yet, the movement it sparked is gaining momentum every month. Lawmakers are watching the pressure build. Constitutional carry is now the law in more than half of the country. But powerful law enforcement unions and anti-gun states are doing everything they can to prevent HR38 from becoming national law. Pro-HR38 bills are being reintroduced in both the House and Senate for 2026. State-level lawsuits are forming to challenge the patchwork of carry restrictions. Police unions are funding lobbying efforts to oppose the bill behind the scenes. 2A advocacy groups are mobilizing voters and publishing national scorecards. Over 30 states now support permitless or constitutional carry. That's a majority. We've seen this before. When the Brady bill passed, gun owners fought back. When the assault weapons ban hit, they organized. And now, history is repeating itself. The outcome depends on whether gun owners remain silent or step forward. One country, one constitution, one last stand. This fight was never just about permits. It's about power, who gets to decide whether your rights are real or simply temporary privileges. HR38 is a line in the sand. If we let states criminalize law-abiding citizens for doing something legal in 30 other states, then we don't have a Second Amendment. We have 50 different rules and zero freedom. Police unions say they want clarity. Well, here it is. Constitutional rights don't end at state lines. And if law enforcement can't distinguish between a criminal and a card-carrying American, the solution isn't fewer rights. It's better training and better lawmaking. This moment right now could decide whether the right to carry lives or die on the road. So here's what to do. Call your representative and demand support for HR38. Share this video so people finally see what's really happening. Subscribe to Firearms Law Advisor to stay prepared for the next legal battle. Because this isn't just about gun rights. It's about who you are and whether your freedom survives the next traffic stop. This is Firearms Law Advisor. Stand firm, speak loudly, and never carry quietly.